Good morning, everybody. Today is November 12th, 2020, and welcome to Mediation, the New Possibilities Hour. Our special guest today is David Brandon. David is a partner in the Los Angeles office of the national law firm Clark Hill. David specializes in representing insurance carriers, particularly at the appellate level. David and I have served for many years together on the Professional Responsibility and Ethics Committee of the Los Angeles County Bar Association, and David is a past chair of that committee. I've heard him present on this topic before, mediating and litigating with burning limits insurance policies. It's an excellent presentation, and I know that everyone will benefit from it very much, both litigators and mediators alike. As we know, this webinar is part of the Will Work for Food project, which Natalie Armstrong-Motan organized in the spring of 2020 when the lockdown began. We are literally working for food. There's no charge for these great webinars. Rather, we ask you to contribute to a food bank of your choice if you like what you see. Natalie, I just love calling on you every week to give the running total. People are many times kind enough to tell us how much they have contributed to food banks, and we keep a running total of that. What is our grand total so far?
Good morning, everyone. Thanks so much for joining us. We are only $1,200 short of having raised $60,000 during our COVID crisis for these Will Work for Food programs, Jeff. I would love to hit that $60,000 contribution mark by Christmas and Hanukkah and New Year's. So we're really hoping that these last few episodes that Jeff has put together really inspire you, and we hope that everyone can make even a small donation to their local food bank.
Absolutely. Natalie, very, very exciting that we've raised so much, and I know we're going to continue to raise much more. David, we would love to hear from you, both the substantive presentation and also please mention the food bank that's important to you, to which you would like us to consider contributing. With that, my friend, the floor is yours.
Thanks, Jeff, and thanks for inviting me here today. Let me share my screen for my PowerPoint, and this is the food bank that I support. There we go. The Santa Clarita Food Pantry. It's an organization that serves the Santa Clarita Valley, which is north of Los Angeles. I live a little bit north of the Santa Clarita Valley. My family and I have served food at the homeless shelter that it supports. We've served meals, and I'm a member of the local Masonic Lodge in Santa Clarita. I'm currently the master, the head of that lodge, and it's an organization that we in our youth groups, because the Masons sponsor youth groups for young men and women, also support. And so if you're so inclined, here's the information. So I want to start off with Admiral Stockdale's famous quote from his vice presidential debate, which some of us may remember, which is, "Who am I and why am I here?" As Jeff said, I'm a partner in the office of Clark Hill. I've been representing professionals, lawyers, architects, engineers, insurance professionals such as brokers and agents, real estate professionals for most of my career. And most of those policies that those types of professionals have are what we call burning limits policies. And over the years, through my own experience and my experience in talking to other people, I began to become aware of the unique issues that arise regarding burning limits policies. And so that transitions from the who I am into the why am I here, because I've given this talk, as Jeff has said, on other occasions to different groups, to insurance company professionals, to defense lawyers, to plaintiff lawyers. And my goal every time I've done that, which is my goal here today, is to identify the areas of concern that are unique to these types of policies and talk about the way it causes those of us involved in these transactions or in this industry to act that may be different than in a non-burning situation. What are the plaintiff's lawyers thinking and doing? What are the defense lawyers thinking and doing? How are the insurance companies dealing with this? And how does it affect the parties to the action? And what is everybody's motivations? And when Jeff suggested that I give this talk to you, to a group of that's focused primarily on mediators, as I understand it, I was intrigued because I hadn't really considered it or spoken to mediators about these issues and how mediators can recognize these issues and how it can help facilitate the mediation process, which is what I hope we'll get to today. And so I'm going to start off by talking about what are burning limits policies. And I know there are a number of people who have dealt with burning limits policies. And so I want you to all bear with me as I talk about it for the people who may be less familiar. They're policies, as it says here, that do not distinguish between the cost of defense and the cost of a settlement or judgment. Or another way of putting it is that every dollar that is spent on the defense cost reduces the available policy limits that would be used to pay for a settlement or a judgment. And I've used this example a number of times to compare the standard policy with the burning limits policy situation. If you have your normal auto insurance policy with, say, $1 million of coverage, and the defense lawyer, me, runs up a bill including my fees, expert fees, deposition costs, jury fees, all those things, and I'll use round numbers because it's easy, of say $500,000, and then we go to trial and we get $1 million verdict. The $1 million is available from, and let me make sure I clarify, and there's a indemnity policy with $1 million limits. So the indemnity of $1 million is available to pay the plaintiff. And the defense lawyer, me, has collected the entire $500,000 in my fees and my costs. So the plaintiff's happy, they've collected the full judgment. The plaintiff's lawyer's happy, they get their fee on the full judgment they obtained. The defendant, insured, is happy because there's no excess judgment against them. The judgment was paid. I'm thrilled because I collected my $500,000. And the carrier is presumably happy because they fulfilled their duties to their insured, right? That's the theory. Now, if we change that to a burning limits policy, the fact that I've incurred $500,000 in defense costs means that there's only $500,000 in indemnity left to satisfy this judgment. So the plaintiff's not happy because they've only collected $500,000 of their $1 million judgment. The plaintiff's lawyer's not happy because they've only collected a fee on $500,000 instead of the full $1 million that they worked for. I'm still happy because I collected the whole $500,000. And the defendant, my client, is not happy because they have a $500,000 excess judgment out there. And the insurance company is thrilled because they've only paid $1 million, the $500,000 to me, the $500,000 on the judgment, the balance of the policy, and they haven't had to pay the full $1.5 million as they would have in the standard policy. But if we change that scenario a bit and we say the policy is only $250,000, that's all different. Now there's no money left to pay any judgment because the entire amount of the indemnity and defense limit has been exhausted. Plaintiff's not happy. Plaintiff's attorney's not happy. Defendant's got $1 million judgment now against them that's not being satisfied. The carrier's happy because they've only paid $250,000, and I'm out there with the $250,000 arguably bill that's not been satisfied because there was only $250,000 to pay, and I don't know if my client can pay me. And just if you think that's an extreme scenario, it's not, as I'll talk about a bit later, because it's happened to me and it's happened to a couple of my partners, although not in quite those numbers. So just briefly, where are these policies found? They are very common in lawyers' policies, lawyers' professional liability policies. In fact, I don't think in California any lawyer can buy a policy that is not a burning limits policy. Same thing with design professionals, architects and engineers, accountants and insurance brokers and real estate professionals. Also very common with directors and officers and employers' liability. It does depend upon the state. Some states have restrictions on these types of policies. There's a possible future expansion into casualty claims, general liability, auto, homeowners. Whether it actually gets there will depend on the state. I know, for example, in California, we have a requirement that the minimum amount of a general liability policy or the minimum coverage has to conform to an old New York standard fire insurance policy, which does not include burning limits. So there may be some restrictions there. But I have seen it in shipping policies, barge collision policies. There's some case law on this where the lawyers were trying to recover fees and they had a burning limits policy and the policy was exhausted. So the advantage to the carrier, as I alluded to in my example, is it removes the variable of total exposure, because the carrier doesn't always know these things. If you talk to underwriters, they're always trying to figure out when they're writing a risk, particularly, say, in a law firm, how many occurrences are there going to be in a particular policy year? They don't know. What are the claims going to be like? Is the lawyer going to, for example, blow a statute on a $5 million personal injury case, or is it going to be a securities fraud case? They try to determine that, of course, through questionnaires in their underwriting. They don't know the difficulty of the defense or whether the plaintiff's lawyers are going to want to just run up the file and do the maximum amount of activity to which the lawyer has to respond. But the carrier will know its total exposure, all right? They're going to know that in a burning limits policy, the most they're going to pay out will be the indemnity limit, as in my example of the $1 million, as opposed to cases where the they're paying both the defense costs, potentially unlimited, and the indemnity amount. And theoretically, the advantage to the insured is lower premiums. I have no idea if studies have been done on that to determine whether this actually has resulted in lower premiums to the insured. Now, why do we care about this? And I call this the first law of thermodynamics because it's akin to what we all learned in chemistry and physics and our science classes, which I'm sure we all took in undergraduate. And I call it, and my version of the law of thermodynamics is that risk, once created, cannot be destroyed. It can only change its form. And that's what's going on here in these burning limits policies, because in the example I gave you, there's always the risk of a lawsuit, of indemnity, jury verdicts. We don't know what they're going to be. Insurance policies are designed also to protect people from defense costs. I don't know how many times I've told my clients when they're out, they're considering starting a business and not being insured because they're never going to get sued. And my students at law school, I teach appellate law, and they always think they're going to practice perfectly and never get sued. And even if they do, well, they're not going to have done anything wrong. And I tell them, do you want to pay me to defend you? And let me tell you what my hourly rate's going to be if you don't have insurance. And then that's when I refer them to, when they're in third year, I refer them to a friend of mine who's an insurance broker who can talk about this more clearly. So, so the risk, all those risks, what's going on here of attorney's fees and potential judgments are being, the risk is being shifted. It's changing its form to being borne by the insurance carrier, and it's now being borne by others, either by the insured client or by me, for example. And so I'll tell you the story how this started for me is many years ago I had a case where I was representing a lawyer who was getting sued by someone, I'll just briefly say, in the entertainment industry without going into too much detail. And I can tell you from the beginning that the lawyer had no liability. The issue was that after a settlement agreement had occurred where there was a confidentiality clause, someone had disclosed the nature of the case and the result of the settlement by sending a copy of documents to the New York Post, which published it all. And I know it wasn't my client. We kind of figured out who it was, a former disgruntled employee of his client. And so he got sued by a Hollywood type, and they hired a very large Hollywood law firm so that there were always 3 partners at every deposition, and every deposition took days, and there were multiple defendants, and so everyone was objecting, and we had to hire a retired judge to sit in at every deposition. And I had gone to the plaintiff's lawyer and I said, look, let's just let my attorney out and let's do a walk away. And they refused, in large part because their client was, intent on vengeance. And so my client had a $250,000 policy, and this was the first time in my career that I actually had incurred a $250,000 in defense costs on a file, which now these days at times seems naive, I guess. But in large part it was because of all the deposition and referee costs. And eventually I will say that we did negotiate a walkaway, which I wish had happened before we exhausted the defense costs. And when it was all over, we ended up with I was in a small firm. There were 2 of us, partner and me, and maybe 1 associate. And we ended up, I think, with an unpaid bill of about $40,000, as I recall. And we had to put out, that was in time only, and we probably put out about $20,000 of our own advancing costs for experts. And so when I went back to the office, I went through the files and inventoried all the files and saw how many burning limits policies we had, a lot of which had been through a Los Angeles County bar program where the limits were only $100,000. And so I went to my partner and I said, these are not assets to the firm, they're hand grenades. Because if any one of these goes off, it can take down a small firm like ours. And so that's when I realized we had to adjust the way we did business because we couldn't continue to business that way. And that's when I got motivated to want to talk to insurance companies and plaintiffs' lawyers about the effects of these policies on defense lawyers and on defendants, and on then the ability to recover by the plaintiffs. Because what happens when lawyers don't get paid? That's when lawyers get into trouble on files. From the defense counsel's perspective, or actually from any lawyer's perspective, when a client stops paying, that's when the lawyer tends to put the file back on the credenza like I have behind me and ignore it, which is the absolutely wrong thing to do. When you have a case where the client's not paying you, or where you're having difficulty communicating with the client, or they're not taking your recommendations as to how to proceed or what the value of the case is, those are the cases you want to get rid of first. You figure out what you want to do. If you can't convince the client to resolve it for a reasonable figure, and they're not paying you, maybe that's the time to move to withdraw, as opposed to waiting till you get close to trial, and then you remain in the case and you don't do the work to build up to trial, and then you're in the situation. For insurance companies, I mentioned this case, this Gibson versus Northfield Insurance Company, which was a case where an insurance company sold a city a burning limits policy. It was an automobile policy, and the plaintiffs got hit by a city ambulance, and the defense costs burned about 1/3 of the limits. And what happened was when the carrier is asserting that it only had 1/3 of its limits left, I think it was $1 million policy, so they were asserting there was only about $300,000 left. The plaintiffs in that case were able to sue the carrier, claiming that the policy violated a particular West Virginia statute that required that auto policies had to protect the named insured against liability for injuries to others. And so the West Virginia Supreme Court held that the burning limits policy violated this statute because it wasn't protecting the named insured from both liability and from defense costs. And so they actually ended up reforming the policy to make it a non-burning limits policy. So insurance companies have had to take notice of the way their policies are going to be interpreted. And and then there are lawyers who advise clients about contracts. I mean, I do a lot of that in my practice. I advise a lot of design professionals in negotiating their contracts with their clients. And I also advise contractors about this. And all of those contracts have provisions requiring the design professional or the contractor to have policies in a specific amount. And so the question is, if the contract says design professional will have a policy, a professional liability policy in the amount of $1 million or $5 million. Some of my clients have had requirements of $10 million, the ones who design airports and things like that. What happens dollar policy that's a burning limits policy? Is that complying with the contractual obligation to have $10 million in insurance? What does $10 million in insurance mean? I think the reasonable interpretation would be $10 million in indemnity limits to pay a claim being made by the owner that is hiring the design professional. And I'm not convinced that a burning limits policy provides or complies with the contract requirements, which could leave the design professional on the hook for the balance, particularly, for example, if you have a situation where there's a limit of liability clause. And the limit of liability clause says that any claim against the design professional or the contractor will be limited to the amount of this $10 million policy. And if the policy gets burned down, does the design professional or contractor have an obligation to make up the difference because they breached the contract by not providing the amount of insurance as required? And there's cases that talk about that a party breaching a provision to procure insurance is liable for the damages that result, which would be the difference between the amount contracted and the amount actually provided. And so I think that attorneys who are involved in these situations should be more proactive and should explain these issues to their clients, either in newsletters, in conversations with their clients, when they're negotiating contracts, when a client gets, when an insurance company assigns a case to you and you realize that the available insurance may be insufficient, when you're having your conversations, it's not a bad idea to tell the client to talk to their broker about this, and whether the broker has adequately explained the risk to the client before selling the policy. So I want to talk a bit about the ethical issues that lawyers face in this regard, and then we can transition into how this affects their situation at a mediation and how this can be dealt with. Okay. So we're concerned with the effect on management of litigation, the lawyer's duties towards clients and insureds, as well as towards insurance companies in states that, such as California, which are tripartite relationship states, where I, as a defense lawyer, hired by an insurance company have a attorney-client relationship, both with the insurance carrier and with the insured client, and how it affects the litigation strategies, tactics, the expectations of the client, the effect on the plaintiff's bar, and then, of course, how we approach settlement. And we have to recognize that, at least from the defense counsel perspective, that there's this tension between the desires of the carrier and the insured. The carrier wants to protect its potential indemnity liability, and the insured wants to preserve the indemnity limits for potential settlement and judgment. And so you get into the situation where the insurance carrier may want the defense lawyer to do a lot of work, take a lot of depositions to demonstrate that the liability is low, whereas the insured doesn't want to do all that work because they want to preserve the dollars for an eventual settlement or judgment. And this is something that I think mediators need to be aware of, because particularly when at times we've gone into early mediations and the mediators may be asking us what we know about the case and what we think the potential liability is, and I'm in a position where I haven't yet done all this work. And so, and I've been asked, well, why haven't you taken these depositions? And it's, well, my concern is that the demand has come in at a high dollar amount. It may still be within the policy. And my client and I, my insured client and I, are trying to resolve the case early without doing the work for the very purpose of preserving the indemnity limits for this very discussion. And then we turn to the carrier who may be there, and the carrier may be asserting that they're not willing to put substantial dollars on the case at this early stage because the work hasn't been done. And then, of course, I'll deal with how the plaintiff lawyer has to deal with in a second. But this is the type of thing that it's quite often we need your assistance as mediators into how to deal with these issues, particularly if the insured client is not sitting there with independent counsel, coverage counsel. Because I, as the defense lawyer, as I'll talk about a little bit later, tend to tell my clients at the outset that I'm not your insurance lawyer. And for any issues that you have regarding insurance, you should hire your own independent counsel. They don't always do that. So, and here's, with that in mind, how do you resolve this tension between the defendant insured and the insurance carrier? And one argument that's been advanced by partners in my firm, I will say, is that they say you don't tell the insured at all about the effect of the burning limits policy. It's not your business, you're the defense lawyer. Because the insured's responsible for knowing its own coverage details. The defense counsel is not supposed to get involved in coverage disputes. And it can open the door, once you start talking about this, to your client, the insured, expecting that you're going to act as coverage counsel on its behalf against the insurer, against the carrier, which we can't do here in a tripartite state. And I personally have this view, which is I tell the insured client everything. I tell them it's a burning limits policy, and I can tell you I've had attorneys that are my clients who have come to me, and we're talking about the case, and I tell them you have a burning limits policy, and they don't know. This is the first time they've been sued, and they've been buying insurance policies for years, and they don't understand the concept. So I explain it, and then I think the most important of this is at the beginning, I outline the suggestive litigation activity, and I state which is most important. Insurance carriers require us to do budgets in any event. And I think an important aspect of that is to not only do a litigation budget, but then in a burning limit situation is to then explain which litigation activity is going to be important. What's our goal? What's the order we should be doing it in, as opposed to just we're going to do everything. Should we take this key deposition? Should we take 5 depositions? Or do we think we can take 1, stop, and reassess? And that's an important aspect from the defense side, is we need to stop and reassess at various stages as we progress, because we don't just keep going and incurring expenses. We do the work, we reassess, and decide where are we now. I also tend to disclaim responsibility for coverage issues, specifically telling them that I am not their coverage lawyer, even though I'm explaining the existence of the policy. And I always send the clients the bills so that they can keep track as to how much the policy is being reduced. And this avoids surprises, and it allows my client, the insured, to make informed decisions. It also deals with their perhaps assumption that, I've been hired to be their lawyer, I'm their lawyer for everything. And as I said, I provide this all to the carrier so everybody, we all know where we are, because we are a team in a tripartite state. And so then the issue becomes, what if the carrier says don't do certain things, or the client says don't do certain things, and the carrier says do it, or the client says, and by client I mean insured client, I am recognizing the carrier is also a client. What happens if there's a dispute between what should be done and whether the work should be put on hold? This can create difficulties because if there are conflicting instructions between clients, or if the carrier has restrictions on recommended activity that the defense lawyer feels should be done, there's an issue as to whether the attorney's duty to exercise independent judgment is being impaired, and it also can create divergent interest between our two clients. And under those conditions, if we can't resolve them, if I have conflicting instructions between two joint clients and I can't resolve it, I may have to withdraw. And so I'm in that situation where I'm trying to tell the client I really need to do this work in order to get a good handle on what the value of the case is, and the client is telling me not to. I try to tell the client what's in their best interest, and I do the same thing with the insurance carrier. I don't think we necessarily need to do that now. I think the best thing to do is to get in front of the mediator before we expend all these additional funds, and we reduce it to the point where we don't have sufficient indemnity limits to resolve the case. And I think that from the plaintiff's perspective, the plaintiff's bar perspective, they also have a duty to keep their client, we all have a duty to keep our client reasonably informed about the status of the matter under the model rules. And so how does the plaintiff's lawyer deal with that? They need to determine at the outset, well, number one, they need to know in which industries, and so they should expect that in a professional liability case or an employment case that this issue is going to. Then they need to determine whether how much is being reduced, and the way they do that, of course, is that when they send out their interrogatory responses or pick up the phone and call me and ask me what the limits are, I can't tell you how many times nobody does that. I mean, I'm amazed at how many times my client gets served with a complaint, and I pick up the phone and I talk to the plaintiff's lawyer just to talk about the case, and nobody says to me, David, what are the policy limits? Or David, do you have, are the limits being reduced? How many claims are there against a normal policy that might have reduced the limits? And so I have to make a judgment call as to, is this the type of case where I'm going to volunteer that information and when I'm going to volunteer that information. And they need to talk to it with their client too, because I can tell you that as many times as I said that lawyers have that I've represented are surprised to find out that they have burning limits in their policies, I would suspect that the vast majority of their former clients or of plaintiffs in these types of cases have no idea what a burning limits policy is. As sophisticated as they may be as business people, if they don't have burning limits policies of their own, this is going to come as a surprise to them. And so avoid the surprise as a plaintiff's lawyer and tell your client. People have asked me after practicing law since '82 and representing lawyers, what's the number one reason lawyers get sued? Is it blown statute of limitations? Is it, conflicts of interest? And I said, no, it's surprise. It's surprise. The client's surprised by something. You've been making settlement demands of $1 million, and then you try the case and you get $500,000, and you think it's the highest verdict for this type of case in your jurisdiction, and the client says, "But you told me I'd get $1 million because I saw all those settlement demands," and you never bothered to tell the client, "Well, this is a settlement posture. I'm not expecting to get this. We're going to get something less." I've had lawyers sued. I've represented lawyers who've been sued in that exact situation. Surprise is what does it. And if you tell the clients what's going on, and you end up with a result that's a bit less favorable than you expected, but you've told them that's possible, then they're not surprised, and they're more likely to accept it. And then the plaintiff bar also has to do the same. What activity is worth burning the limits down? Which depositions do I take at the outset? Maybe I don't take depositions. Maybe we sit down and talk to the defense lawyer. Figure out the cost of burning down the limits, estimate what the defense lawyer is going to charge, and talk to the client about, do we go in early, make early settlement demands? Do we do early mediations? And be more cooperative with defense counsel. And as I said, from my perspective, do I reveal that there are burning limits? And I really can't think of a situation in which I wouldn't. In fact, when I respond to discovery about what the limits are, I don't. There are still lawyers who just put down $1 million per occurrence, $3 million aggregate, and don't add subject to declining limits, which I think is required to give an accurate response to that question. There is a case in California where an insurance coverage lawyer was sued for fraud by misrepresenting the amount of available limits on a policy. Now, I don't think that I, as a defense lawyer, could be sued by my opponent for misrepresenting what the available limits are, because I think I'm protected by the litigation privilege. But what I'd be more concerned about is not revealing the limits. The case progresses, the result is the limits get burned down and there's an excess verdict or judgment, and my client then turns to me and says, "Why didn't we settle this earlier? What steps did you take to try to settle it earlier? And what do you mean you didn't accurately state what the policy limits were? And is that the reason I'm in this situation today?" There should be a recognition that when the well runs dry, the lawyers can't simply cease representation. We have to make motions to withdraw, and we can't always get out, actually. I've had one of my partners was in a situation where he was representing a structural engineer, as I recall, who had designed some scaffolding for the building of an oil tank, and to hold up the roof of the oil tank while the workers were on top of it. And so the roof collapses, and so of course everybody gets sued, and he was able to demonstrate to the satisfaction of the plaintiff's lawyers, who were very sophisticated, that the that the structural engineer was not at fault. It was an issue with defective scaffolding supplied by the scaffolding company. And his policy, he exhausted the policy and the defense costs and was trying to get them to dismiss his client, and they wouldn't, for an interesting reason, which is they knew that he could prove their case against the scaffolding company for them. And so that's what he ended up doing. He ended up trying the case, defending it for our client, the structural engineer, and proving the case that there was a defect in the scaffolding, which enabled the plaintiff's lawyers to collect a fair amount of money. But we ended up with a large unpaid bill because the wellhead run dry. It occurred right around the time the case was going to be tried. And I remember we talked about it, and, could he have made a motion to withdraw right at trial? Maybe. Would it have been granted? I don't know, probably not. But he decided not to do it because he felt he had an ethical obligation to represent the client under these conditions. And our firm ate a fair amount of fees, but none of the partners criticized him, fortunately. We were a smaller firm then, and much chummier, let us say. And so I think the carriers need to encourage defense counsel to address these issues and to inform the insured clients and to keep everybody informed of progress. And I think that the insurance carriers should be the ones cooperating with us on the priority of litigation plan items, and need to be more receptive to us as defense counsel when we pick up the phone and say, look, we're concerned that this policy, we're going to exhaust this policy, and we're going to be in a situation where we're not going to be able to get paid, and so we need to try to resolve it now. And it will foster good relations with the insurance carriers and their defense counsel if everybody understands everybody's perspective in this, as opposed to insurance carriers just assuming, well, when my last dollar is spent, I get to stop paying on the case and my defense lawyer may have to continue on. That's not my concern. It brings up the issue as to whether the carriers have a duty to avoid unreasonable defense activity and try to settle early and to continue defending if the insured disputes the exhaustion. Because then you get in a situation which has occurred in Los Angeles. There have been lawsuits where insureds have sued defense counsel and carriers saying the work that was done was not necessary, and so my policy was exhausted improperly, and there should still have been limits available to satisfy the eventual judgment. And which brings us to mediators, which is, how can you help us in this? I mean, Jeff and I were talking about the issue of mediators and whether mediators should get deeply involved in this, because I know many mediators are not attorneys. It seems to me, from my perspective, I'll tell you as a defense lawyer, my most satisfactory mediations have been those where the mediators have done more than simply looked at the value of the case and potential verdicts and strengths and weaknesses, which of course is all essential, but also looks more, I guess, behind the eyes of the parties and looks at their motivations and looks at issues that I, as a defense lawyer, may not necessarily recognize exist in terms of the personalities. I mean, I was talking to Jeff about a case I have where a woman rode a scooter for the first time at a shopping center, falls off, and has significant brain damage. And I'm representing the center. And the claim, of course, is that we should have warned her that scooters are dangerous, okay? And they're suing us, they're suing the scooter manufacturer, and they're suing the city, saying the city should have regulations about scooters and safety regulations. And if you look at the publicity they've done and the interviews they've done, it's clear that they have a vendetta, and so do the lawyers who want to make a name for themselves in this particular industry. The clients have a vendetta against scooter companies, and the lawyers want to make a name for themselves. How do we resolve a case like that for a reasonable figure based upon the fact that I don't think there's much liability? And that's the type of thing that mediators, of course, have to consider, which is the motivation of the parties. So this type of issue here, where we're looking at the potential for scorched earth litigation, doesn't benefit anybody, could result in plaintiffs not recovering full value of a judgment and defendants being left with excess judgments that are going to haunt them for 10 to 20 years. Defense lawyers are going to have unpaid bills. Plaintiffs' lawyers are not going to recover the maximum value of the case. How do we deal with that? How do we deal with what work needs to be done? Do we do, which we've done before, also sequential mediation? Okay, everybody sits in a room and we figure out what work should be done. And we do a little bit of work, and then we come back for a second session. Okay, what have you guys discovered? Well, we still think we need to spend X number of dollars, do a little bit more, and we've done that too. And so at this stage, I guess, since I was told that the last 15 minutes are kind of left for questions and discussion, I guess at this point in time, I'd like to know what people think about that and the experiences they've had, and what can we do as defense lawyers, or sometimes I am a plaintiff's lawyer. I don't tell some of my partners about that, but I've done some plaintiff's professional liability work. And where are we, and what can we do in that situation, I guess? Is that appropriate at this point, Jeff?
David, that's great, and thank you very much. This is really soup to nuts, everything you need to know about burning limits insurance policies. Let's focus in a little bit more directly on the mediation aspect of it, and let me start out by asking you, what have you seen mediators do in cases involving these burning limits policies that's good, and what have you seen us do that's not so good?
Well, I think the thing that I found that has not been good has been the situations where the mediator is unfamiliar with the burning limits concept, which is, it's not very common, I wouldn't say. It happens all the time, but it's been a substantial number of times. And I've had to, I don't give this presentation, I don't carry it with me, but I have to explain the situation and explain why I haven't done the work that they would have expected me to do. And it's, by the way, it's not just mediators, it's also been mandatory settlement conference judges who wondered why haven't you taken the deposition of these key witnesses? And I have to explain why. And so that's been an issue. And it's also been an issue as to the fact that they haven't necessarily explored that with my opponent or opponents. All right. Particularly with, representing design professionals, I'm often in a situation where the other parties to the case, the contractors and subcontractors, the general contractor, the tile installer, plumber, they don't have burning limits policies. And so they don't understand it either. And so maybe what has been, what I have found beneficial in those types of cases is when we've had a pre-mediation conference call where the mediator has gotten everybody on the phone and has said something like, what are the key issues we're going to be talking about, that you see are the key impediments here. And we don't, of course, we don't spend 8 hours, but maybe we spend a half an hour on the phone with everybody, and I bring this issue up. And then I get a mediator who says, okay, I see that, let's talk about that, and maybe the mediator and I have a separate conversation, and then they become more familiar with it, and then we kind of we don't plot a strategy, but there's a discussion as to how this is best raised and best discussed amongst the parties. That's kind of
Okay.
the way I do it.
And are there techniques that you've seen mediators use, either with very aggressive policyholders who want defense, or very aggressive plaintiffs who think that by driving up the cost of defense, they'll encourage a carrier to settle? What have you seen mediators do that has been effective in getting both policyholders and the third-party plaintiffs to call off the fight and preserve the funds for settlement?
Well, I'm usually not in the room when they're talking to the plaintiffs, so I'm not really sure about that. And I haven't had a situation where I, as a plaintiff's lawyer, have had to have somebody explain that to me, because I've known it going in. But from the defense standpoint, I've had clients who are frankly frightened, I guess is the way to put it, that they're going to end up, that they have insufficient limits. Okay. And so it is always nice when the mediator says, well, but you have this great lawyer on your side and he's not going to let this happen. And, you know, and I think the effective strategy or the effective technique has usually been to, at some point, have had the carrier and the insured client in the room together talking about this and coming to a common ground and developing a strategy. Now, I have I'm not perfect, but in almost every case, I've already laid that out in advance. And what the mediator has done is definitely reassured my client that, yes, what David has suggested in doing this incremental work and then reassessing is going to be the best strategy to protect you, in that you have to spend some money. It's going to be relatively limited at the outset, and then hopefully that will enable us to get to a position where we can then get a reasonable settlement from the plaintiff. So there's a lot of hand-holding, I guess, is the way to put it.
Okay, thank you. Janice?
Morning. Thanks for that really interesting talk. I actually was fairly ignorant about burning limit policies. And
Janice, please speak a little louder.
I said thank you for that. It was very informative, and I was pretty ignorant about it, so I've learned a lot. My question is this. Do you ever face a situation where you can get into a malpractice situation because you deferred discovery? In other words, they're saying, well, you didn't take these key depositions because you were worried about the policy limits and therefore didn't adequately represent me or whatever. I'm not saying it's valid, but I could see how you could get caught in a catch-22.
Yes, and I alluded to that in some respects a bit earlier when I mentioned the fact that lawyers who are not getting paid may tend to put the file on the back burner, or lawyers who don't think their client and they can get to a reasonable, are on the same page. The case is going south for whatever reason. They don't think the case is worth as much as it was, and so they don't think it's worth their time, and so they put it on the back burner. And then suddenly there's a trial, and they haven't done all the work. Okay. Now the same thing can happen in a burning limit situation, but you have to be vigilant about that. You have to, number one, as a defense lawyer, you have to lay it out to the client and to both clients, the insured client and the carrier. And that's why I mentioned what I do is here's my budget, here's my recommendation, and here's the work we're going to do sequentially. And then you get everybody to buy off on it. Okay. It is now I will have sent this as an email or a letter to both clients, and I always at the end say, I'm going to proceed in this fashion unless I hear to the contrary. Okay, I don't say please respond with a yes to my email. Okay, I'm not that concerned, but I make sure that it's that there is that catch at the end. Everybody agrees to this unless I hear to the contrary. And then you have to be vigilant. So then you have to do the work. And then when you do the work, you have to send the next report and you have to follow up. Okay, we've done this. I've now determined, or you've been deposed. And I've determined that you're a horrible witness. Of course, you don't put it in quite those words, but I'm concerned that because of the way this was phrased or the lack of documentation, which is of course a big thing with lawyers, that a jury could find adversely to our position. And so now we're in a position where I think the case, we may want to settle. And if we don't and we do this work, here's how the limits are going to have declined. And as long as you document yourself that way and you don't ignore this issue, I think you're fairly well protected from a malpractice claim. Okay.
Thanks. Richard?
Yeah.
Thank you. I have a question. When I look back on my initial conference calls with the counsel, which is in every case I have that, I'm wondering whether it would be seen as appropriate or inappropriate for me to test the waters with everybody present, I mean, not the clients, but just the lawyers, saying, have you discussed or do you know what the insurance policy situation is? Or is that something that you would only do, or you feel a mediator should not do, only do it in caucus with the lawyers themselves?
I think in most cases, that has been just amongst the lawyers. The initial call that I mentioned is usually just with the lawyers. We don't have the clients on the line, although there have been situations where certain clients insist on being, on every call, on every communication. But I think that initial discussion should be amongst the lawyers, because what I would prefer not to happen would be for a plaintiff's lawyer to get blindsided by something in front of their client, or a subcontractor's lawyer to get blindsided in front of their client and say, I didn't consider that. So and then you end up with a situation where the lawyer loses the client's trust or confidence, and then we're not in a position to settle because now the client is suspicious of what's going on, and then it's far less productive under those conditions.
That's a very good point. My question was whether it is appropriate with both counsel from both sides, no parties, to bring it up as just a matter of an issue to discuss. Or
you mean with both in the same room at the same time?
The lawyers, yeah.
Yeah, I think that's preferred.
Okay.
Yeah. Then everybody knows everything. Everyone's on the same ticket.
Bill, one last question, please.
Yeah, thank you, Jeff. Just to follow up on that point, as a defense counsel who defends lawyers and professionals in these types of situations, and who has been stung by the burning limits, and my client has been stung, I think the sooner you can have that conversation with opposing counsel, the better, because getting them caught off guard at a mediation where they may not be sophisticated enough to know about the burning limits policy, that's going to tank your mediation, because now you have tension in the other room there, who's, with their client going, why didn't you tell me about this? Did you know about this? I think it's crucial and can't be overstated enough that conversation ought to be early on. And like you, David, I do the same thing. When they ask that interrogatory in discovery in California, the 4.1 and the form logs, what type of insurance policy, or if there's insurance, what are the coverage limits and whatnot, I make it a point to say it's burning limits policy. So then, I think I'm protecting myself, so I'm not misrepresenting anything. And the other side knows, because I got into a case, went to trial a couple of years ago with a $500,000 burning limits policy and I get a 998 statutory offer because I had two defendants, partners, where the plaintiff lawyer made two $500,000 statutory offers, thinking that each lawyer had a $500,000 limit, which obviously was not the case because they were burning limits. And by that point in time, it was one limit of 500,000, which at that time was probably at 250. And so he didn't understand that. And then I got a 998 for $300,000, which created a whole other problem about I had to get my client coverage counsel and all that good stuff that goes along. So I think the sooner you get plaintiff's counsel educated, if they are unfamiliar with burning limits policy, the better chance you have of certainly resolving it with some type of mediation.
Yeah, I think that's a very good point. Very good point.
Okay, Bill, thank you for that. And David, thank you for a very educational and illuminating presentation on a nook and cranny of the insurance world about which many of us don't know as much as we need to. And certainly if we're dealing with professional liability situations and employment practices situations, directors and officers situations particularly, we need to know about this. So David Brandon of Clark Hill, thank you very much for the presentation. We're at close to $59,000 raised for food banks. We really hope to hit that 60,000 mark this week. If you're listening live, if you're listening to a recording, if you're in a position to support, we really appreciate that. David had mentioned and encouraged us to contribute to the Santa Clarita Valley Food Pantry. That's scvfoodpantry.org. Right, David?
Yes.
Thank you. And Natalie, any last words from you, please?
David, thank you so much for the fascinating conversation. We really, really appreciate your time and contributions to Will Work for Food. What an interesting look at something that I really didn't know very much at all about. So thank you for that.
My pleasure. Thanks for the opportunity to speak to you and to bring this to the attention of more people.
Okay, my friends, with that, we are complete.